This is a short webinar on charity incorporations, why charities incorporate and some of the key issues that come up when they do. My name's Gareth Roy. I'm a senior associate in Russell-Cooke's charity team, and I'll take you through an overview of the process and how it works. And my colleagues, Carla and Claire, will then focus on some of the more specific issues that come up when dealing with charity property, employees, and data protection matters. So to start with, I wanted to talk about what it means to incorporate a charity at all. So there are different legal structures available to charities. 4 main structures are on this slide. The first 2, unincorporated association and charitable trust, are examples of unincorporated legal forms. And the second 2, a company or a CIO, are examples of incorporated legal forms. And the process of incorporating a charity involves swapping from an unincorporated form to an incorporated form, so making that change of legal structure. So why do some charities go through this process? What is the main reason why they might look at doing that? The answer is to try and minimize the risk of personal liability to trustees and others involved in the charity. And this is because if you have an unincorporated legal form, it has no separate legal personality from the individuals involved in the running of the charity. That means that all of the legal relationships that the charity holds are technically in the name of individual trustees or others. And what that means is if anyone wants to bring a claim against the charity in future, that claim is actually properly made against individuals, normally the charity trustees. Now, one would hope that there's some insurance cover or sufficient assets that the charity holds to meet those liabilities, but that is obviously not always going to be the case. So there remains a residual risk of trustees having their personal assets being put at risk through their volunteer roles, which obviously isn't ideal and isn't something that some volunteers want to be the case. By contrast, if you have an incorporated legal form, such as a company or a CIO, it does have separate legal personality from the trustees. It can enter into legal relationships in its own name and hold its own assets. And if someone wants to sue the charity, they can sue the charity as an entity itself. And generally speaking, the individuals running the charity are protected. Even in a worst case scenario, if the charity didn't have sufficient assets to meet a liability, it could go through an insolvency process and the trustees would be protected. So that's the main reason why charities look to incorporate. And I just wanted to mention that there are some other legal structures available to charities too, but they're less common, so we're not going to cover those here. This slide just summarizes some of the pros and cons between incorporating or not incorporating. The main one we've obviously already talked about, and that ties into the second pro for incorporating, the ability to attract and retain trustees who are generally volunteers and might be concerned about any potential personal risk that they're put under. Also, ease of administration. If a charity can hold assets and contracts in its own name, it makes the administration easier because you don't have to switch them across into new names when new trustees are put in place. And that's particularly helpful when dealing with property assets, as Claire might mention later on. Final advantage to mention is sometimes other stakeholders' perceptions of the charity. There's an idea of professionalization that sometimes comes with incorporating that can help with things like certain accreditations or getting a certain transaction through. Of course, a sensible trustee board should always consider both sides of the coin, and therefore reasons why incorporating might not be the best thing for a charity on occasion. The key thing to consider is the amount of resource and cost that will be involved in incorporating the charity. This will vary quite a bit depending on the size of the charity and the complexity of its assets and liabilities. So there needs to be a bit of an exercise to work that out at the outset. A very small charity might have simpler governance and filing requirements if it retains its unincorporated form. This is typically quite small charities indeed. And finally, when you carry out this due diligence exercise, what assets and liabilities does the charity have? How complex will it be to move all of those across? You might find something that will prove very difficult to move across. For example, if a data protection issue is identified that you can't quite find a solution to, or an easy solution to, and that might be a reason to stay as you are. So if you decide to incorporate, how does a charity go about doing this? There are two options in terms of how this can be achieved. The first and most common option is a full incorporation. This involves setting up a new corporate charity and transferring all of the assets and liabilities of your current charity into the new corporate charity and running everything through the new corporate charity in future. So conceptually, nice and simple, you've just got your new charity that you run through. The second option is less commonly used, but if you have a charitable trust, you could replace the individual trustees with a company that becomes the sole trustee of the charitable trust, and the individual trustees become the directors of that company. That's clearly conceptually a little bit more complicated, and typically charities don't tend to choose that option unless there's a real reason to look at it. And that can get quite technical, but very briefly, normally that's where a charity holds significant amounts of property on permanently endowed trusts. But for the remainder of this webinar, we'll be talking about full incorporation, which is the most common route. So the steps to achieve a full incorporation in brief are deciding on what legal structure you want your new corporate charity to have. Should it be a company or should it be a charitable incorporated organization, or CIO? There are some differences between the two, and you can seek advice on the specifics depending on your context as to which might fit you best. Normally, in our experience, particularly smaller charities prefer a CIO, which is just regulated by the Charity Commission and not by Companies House. Then need to have a constitution drafted for the new corporate charity, which obviously will need to be tailored to your governance requirements. Do you have a wider membership, for example? And if it's a company, it will need to be registered with Companies House. The next step in the process is to complete a detailed online form to the Charity Commission, applying to have the new charity registered. And although you might think, well, we've been operating as a charity for many years, albeit through a different form, so hopefully this should be quick and easy. The reality is it is a detailed form that you have to complete, and the Charity Commission carries out a good level of due diligence on all applications it receives for new charities. So it will look at it closely and it can ask further questions. Also, it can take several months to go through this process sometimes, depending on how quickly you're able to move things forward with the Commission. Once, fingers crossed, your new corporate charity is registered with the Charity Commission, you then need to transfer all of the assets and liabilities from the old charity to the new charity. In terms of how those assets and liabilities are transferred and what work is involved, it will very much depend on your charity and on the complexity and size of the assets and liabilities that the charity has. So some particular things to look out for are listed here in terms of land, employees, contracts, particularly big, important contracts or large amounts of grant funding you've received. It's important to check those documents and see what steps you need to go through to move those across to the new charity. Databases, which Carla will of course talk about in a moment, and investments. And there may be other things that come out of your short internal due diligence exercise, just confirming what exactly do we have and how do we get them across. In the vast majority of cases, it's necessary to go to the Charity Commission for an order to approve the incorporation terms and to ensure there's a provision in your transfer agreement that protects the trustees from any historic liabilities that could arise in relation to what the charity did before it was incorporated, which is quite important to make sure they have that protection. I also wanted to mention that some charities choose to keep the unincorporated form open as a shell, either for a limited period of time to deal with administrative issues, such as getting standing orders across to the new charity's bank account, or sometimes for a longer period of time to try and minimize the risk of losing any legacy income from wills. I should say that there's hopefully going to be a change in the law in autumn 2023, which will mean that there's less of a need, or potentially no need at all, to retain an unincorporated charity as a shell for the purpose of receiving legacies. But we will wait and see on that one. Then I'm going to hand over to my colleague Claire now to talk about some of the particular issues that arise with land when you're incorporating a charity.
Thanks very much, Gareth. So I'm a senior associate specialising in property law for charities. So yes, you've decided to incorporate. As part of that, you're going to be transferring things to the new corporate entity. So one of the things to do due diligence on is your property, work out what you own and on what basis you own it. So do you own a freehold, a leasehold, or are you actually occupying under a license to occupy, which is a slightly different thing, a kind of personal contractual arrangement to be somewhere. So gather together all that information so that you have it to hand and can see what you're dealing with. Assuming that, because I'll go on in my next slide to talk about the various restrictions that might affect your property that you need to be aware of. But assuming, for example, that you've got just one freehold property owned outright, no restrictions on the title. One of the things, one of the things Gareth mentioned earlier was the fact that as an unincorporated charity, you own things in your individual names. And a problem that can often come up with property, and is another reason to incorporate, is that people often forget to update the title when someone dies or a new trustee comes on board, etc. So often we'll see that the title is actually held by people who are not the current charity trustees. And there are basically ways to deal with that. I mean, ideally, you just find the people who originally entered into the document, see if you can persuade them to sign, and then Bob's your uncle, because the people who own the property have signed the transfer. However, if people have died or aren't willing to sign, then there are various ways that you can deal with that using Trust Act and Charities Act provisions. But anyway, it's something to find out, and then something that people like us can deal with. Then moving on to my next slide. If it's perfect. Yes, so in terms of restrictions and consents, so I mentioned looking at a copy of your title. That will tell you quite a lot about things that affect the property. So I come on to mortgages later. That's something that will usually be registered via a restriction or a legal charge against your property. But there may also be other things on the title that might even mean that you can't transfer the property at all, or that there are various difficulties with doing so. Also worth checking the planning position related to the property, because sometimes you can have personal planning permissions which name this specific charity as being the only entity that's allowed to operate from the site. Hopefully you'd be able to find ways around that, but that's something to check as well. Then Gareth mentioned special trust and permanent endowment. A special trust is anything where you are obliged to use your property for your charitable purposes. So, for example, to house the blind, for example. And then permanent endowment is when you are only allowed, you can sell something, but the proceeds of sale must be retained as a capital fund rather than and then the income be spent rather than the capital itself being spent. Anyway, either of those will count as, in effect, a separate charitable trust in its own right. And that means that the receiving organisation can't receive those assets outright. They have to hold them on trust. And that's sometimes a reason why, going back to Gareth's two options earlier, you might choose the corporate trustee route, because then you'll still remember that you hold these things on trust. But it is still possible to go through a full incorporation. What you decide on will depend on how much of the assets are this kind of special trust or permanent endowment. Then on mortgages, so you might have an actual commercial mortgage with a lender, or you might have something that secures grant funding that was given to you in the past. Generally, that'll be on the title, and it'll prevent you transferring the title without getting the lender's consent. So you'll need to approach the lender, and often banks in particular can be really difficult in that scenario and can insist on taking, or on not only taking their charge off and putting it back on again, which they don't technically need to do, they can novate it instead, and also just trying to redo all of the due diligence that they did to start with. So if you can try and get in a good contact with the bank and explain to them that it's just exactly the same organisation as before, or effectively it's just got the benefit of limited liability, then try to do that so that you don't have to spend loads of money on the bank's due diligence. Also, if you occupy under a lease, then you're going to be transferring the lease, the ownership of the lease, to a new organisation, and so you'll need to seek your landlord's consent. Under the Charities Act, as it currently stands, there's a potential loophole which would mean you didn't have to seek their consent, but usually what you would do is use that to negotiate with them that they don't need various things that they'll ask for under the lease, and that you don't need to pay their fees, etc. And we've tried that a few times, but generally speaking, you would get your landlord's consent and then have to pay their legal fees for the transfer of the property. And also you'll have to deal with anything. You need to look at your lease document and see whether you need the new organisation to enter into a direct covenant with the landlord, give a notice of transfer after the transfer has taken place, etc. Also, if you happen to be a landlord to other tenants, then you'll need to give notice to them of the fact that you're now a different organisation and they'll be paying their rent to a slightly different entity. That's it on the property side. I'll now hand over to Carla.
Thanks, Claire. So Gareth mentioned I'm a partner in the team, and I specialise in employment and data protection law for charities. So I'm going to briefly touch on both of those topics now. The first one, looking at your employees, your staff, and the impact that incorporation could have on them. As Gareth mentioned, we're really focusing here on full incorporation. The things I'm going to talk about here wouldn't normally apply if there's instead a decision to put in place a corporate trustee. So once again, this is why doing the thinking in advance is so important, because it's possible that these kinds of issues might be the deciding factor between whether you go for full incorporation or something different. So on the employee side of things, the key thing to remember really is that your employees will transfer to the successor charity. So it can be a bit of a conceptual sort of gets conceptually confusing process, because you see yourself as exactly the same organisation and your staff see yourself as exactly the same organisation, and it feels just like a technical change. You're going to get a company number and there's some legal differences. It does have a wider employment law impact in most cases, in that CHUPI will apply, and that's a piece of legislation that automatically transfers the employment and the employment contracts rights of staff between one organisation and another in certain situations. As I said, in most cases, CHUPI will apply on a full incorporation. It's possible that there might be asset transfer sort of arrangements where CHUPI wouldn't apply. And, you know, if there is any doubt, I'd say you obviously take advice, because if you proceed on the basis that CHUPI doesn't apply and then you don't comply with your obligations, there can be some quite costly claims that employees can bring against you. And they're known as protective awards, and the penalties can be quite significant. So even if it feels like a very administrative paper task, don't ignore it. As with pretty much everything that we talked about today, first step is due diligence. Who are the staff? What kind of contract terms do they have? And what will be transferring? If you are going to make any kinds of changes, or you want to make any kinds of changes to contracts or employment benefits at the same time as incorporation, that's a really key thing to think about in the CHUPI context, because that can make the difference between not just having to notify your staff of the transfer and provide certain information, and also having to consult with them. So I've put on here just those bullet points to remember. As I say, it's quite a technical area. So I do think that unless you happen to have someone within your organisation who's already quite familiar with TUPE and the requirements, this is really one of those areas where getting a little bit of advice upfront, hopefully wouldn't be too complicated, can save you the potential for protective award claims further down the line. The other main point to note on incorporations and kind of restructures in general when it comes to staff is pensions. Now, we're not pensions experts, but we do work with partners, trusted partners who can give expert pensions advice if you do find yourself in this sort of situation. But the key thing to remember is if you still have a DB, a defined benefit pension scheme, and the restructure, so the incorporation here, is going to mean that your employees are going to come out of that scheme effectively. The risk is that it could crystallize what's called a Section 75 debt. And the headline really there is that can be very costly, and most of the time you would not want to be triggering that. So if you do have defined benefit schemes in particular, really do take some pensions advice before you go ahead and incorporate in a full incorporation. So moving on to talk about data protection issues now and the transfers of kind of databases and data assets. The key thing here is to remember that if it's full incorporation and you're transferring assets across, then personal data of people like your staff, trustees, volunteers, supporters, etc., your marketing lists, your donors, clients, service users, that is all going to transfer from one controller of personal data to a new controller. So the new company that you're putting in place is going to be a separate controller of personal data. That means that in data protection law terms, there is a data transfer happening. Now, I've put here the ICO's data sharing code of practice is something to have regard to. The ICO is the Information Commissioner's Office. They're the regulator for data protection in the UK. You can go onto their website, search for data sharing code, and there's a section in there which is called mergers, but it really applies to any sort of restructure of this kind. And you can see that it tells you what kind of due diligence you should be carrying out, and then it encourages you strongly to put in place a data sharing agreement. That might be just something relatively simple that becomes part of the transfer agreement that you're doing, or depending on the complexity of the kinds of data you hold and what you do with it, it might be that you think having a separate transfer agreement would be a good idea. Again, it becomes a bit technical quite quickly, so I think it is worth kind of getting some advice. Particularly, I think the final bullet point on this slide is the one that I'd encourage you to really think about carefully before you decide to press ahead with an incorporation, full incorporation. And that's the issue of consent. As many of you might know, consent under the GDPR and the new data protection laws that came into effect a few years ago is a kind of high bar. So crucially here, for the sake of what we're talking about today, you need to get consent for the specific controller of the personal data to use the data in a particular way. So it will have to name Russell-Cooke, I agree that I consent to you using my data. If you try to just say, and any other companies or charities that we ever merge with or become, it won't work. You can't have those just big classes of controllers. It has to be specific. So if you've gone out and got consent from people for your unincorporated organization to use their data in a certain way, then strictly speaking, you wouldn't be able to rely on that consent when you transfer to the new organization, because they didn't give consent to that particular controller using their data. Now, again, a little bit like I was saying with the staff issues, this feels very technical and it feels like a little bit disproportionate. I think a lot of charities do make a risk-based decision, but you want to go into that with your eyes open. The key things there will be things like, what kind of data are we talking about? The difference between getting consent to send an annual newsletter by email and the difference between using consent to collect and use and share people's very sensitive confidential data may be the difference between you deciding we can take the risk that people will assume that we're still the same organization and won't have a problem with us using their old consents, versus you thinking about the risk associated with saying, oh, well, actually, technically, you didn't give us consent to use information about your health or criminal convictions or something like that. So understand the risks and then take steps to manage them if you are going to press ahead with the incorporation. And that could be anything from going out and re-consenting everybody through to taking a calculated risk-based decision that you're going to seek to rely on the old consents. So as I say, some quite technical points to think about. Make sure you consider those before you go ahead with the incorporation. But I think for the purposes of today, those are the headline points that you really need to be aware of when you're thinking about data assets. So final kind of thoughts from us. If you do have any questions, we've covered a lot of topics today, and obviously a lot of the answers to these points that we've been raising will depend on your organisation, the work that you do, kinds of property or other assets that you hold. So you really do need to think about it on a case-by-case basis. Get in touch with us. You'll have our contact details at the end here. Any of us will be happy to have a 10-minute call with you initially, and then if you want to take that forward, we can work with you. Thanks for attending today.